Welcome to the 2020 Virtual Spring Meeting, brought to you as a special edition of Our Curious Amalgam, the American Bar Association Antitrust Law Section's podcast. Virtual springs eternal, Friday, April 17th through Friday, May 1st, as we bring to you some of the top programs from the now canceled in-person spring meeting, as well as new hot off the press programs discussing the most compelling issues of the day. Be well and enjoy the show.
Hello and welcome to the Virtual Spring Meeting. My name is John Roberti. And today we are going to present yet another great panel. Today's topic is Honest Broker or Advocate, Effective Expert Testimony. With me today is Jim Langenfeld. Jim is with Ancora Consulting in Washington, D.C. He's also the co-chair of the Economics Committee. Jim, how are you?
Very good. How are you?
Well, I'm great. Thank you. So, Jim, what are we talking about today and why is it important?
Well, I understand that the question here is the role of the expert, whether they're a broker or an advocate, and the type of testimony that you can expect them to give. And this is really important for economists and attorneys because in an antitrust case, at least, they all require, or virtually all seem to require, expert testimony supporting either class certification, liability, damages, or causation. And absent this type of testimony, the plaintiff's cases typically collapse, in my experience. And then clearly the defendants, to put up their proper defense, need their own experts to be able to counter the positions that the plaintiff's experts have taken, if they so can do.
Jim, we have a great set of panelists today. What do you expect will be covered today on the panel?
Well, these are a great group of veteran attorneys and economists. And I would anticipate some of the relevant questions that they would touch on would be how and when to select an expert for their team, and actually an expert and the team that would support the expert. Does it make sense for more than one expert or support teams? What's the role of the expert in the overall architecture of the case? In other words, how much of the case should the expert try to carry in terms of testimony and evidence? Also, probably the role of the expert, the support staff, the lawyers and the courts in shaping and writing an expert report or declaration. There clearly are those in virtually all these cases. And finally, how to prepare an expert for deposition testimony or court testimony.
Jim, great. You and I sit back and listen, and let's send it down to Ian Simmons, the moderator of today's panel. Let's kick it off.
Thanks very much, John Roberti. Good afternoon, everybody. Good day. My name's Ian Simmons, and it's my privilege to host this ABA Spring Meeting podcast entitled Honest Broker or Advocate, that is expert witnesses. We're dealing with expert witnesses, and our distinguished panel today will discuss this supposed dichotomy between an expert being an honest broker or an expert being an advocate. And it's my real privilege to introduce the panelists. We have Belinda Lee, who is a graduate of Harvard Law School. She is a global vice chair of Latham and Watkins Antitrust and Competition Practice. Belinda represents global companies in high-stakes litigations and investigations with a particular emphasis on defending private damages actions throughout the world. Belinda has a marked distinction of defeating class certification several times in antitrust cases, which we on the defense side know is a difficult undertaking. Belinda is a fellow of the American Bar Foundation, and she serves on the board of the Asian American Advancing Justice. She is the global chair of Latham and Watkins Career Enhancement Committee, and it's been my real privilege to have had the opportunity to work with Belinda over the years. We also have on our panel Scott Martin. Scott is a double Stanford graduate. He is the co-chair of the Hausfeld Antitrust Group. Scott is a persuasive and forceful advocate, and he has a unique perspective really in our bar because he's had a career both predominantly on the defense side and of course predominantly on the plaintiff side with Hausfeld, a firm he joined in 2015. He has a distinguished record in major antitrust cases, both on, as I said, on the defense and plaintiff side. And he is a an advocate of integrity and high intelligence. He's negotiated the resolutions in a number of prestigious antitrust matters. He's currently serving as counsel in In Re NFL Sunday ticket litigation, In Re LIBOR-based financial instrument antitrust litigation, and In Re Blue Shield antitrust litigation, just to name a few. So welcome and thank you, Scott and Belinda. We also have on our panel Dr. Lauren STIROH. So we are mixing lawyers with non-lawyers, with economists. Lauren is chair of NERA's Global Antitrust and Competition Practice. She has her PhD in industrial organization from Harvard University. Lauren specializes in the economics of antitrust, with a particular emphasis on the antitrust analysis of intellectual property rights and conduct relating to intellectual property. She has presented her research to DOJ and the FTC, and she's testified in various FTC hearings on intellectual property and issues of market power. In addition to testifying in federal court on issues such as exclusionary conduct, tying, and vertical restraints, Lauren has a distinguished record of publishing. So welcome, Lauren, and thank you for all your contributions. Our final panelist today is Rob MANESS. Rob is Vice President of CRA. Rob holds his PhD from Texas A&M University, where he is also a visiting professor. Rob has extensive experience with large antitrust litigation and merger analysis, as well as conduct matters relating to intellectual property, transfer pricing, and the assessment of impact and damages. Rob has testified quite notably in a damages case in a high-profile pro bono case involving human trafficking in federal court in Louisiana. So Belinda, Scott, Lauren, and Rob, thank you for all of your contributions. Let me start off, if I could start with Scott, please. We want to start with how and when we think about selecting an expert witness. So Scott, plaintiffs typically initiate the case. As a plaintiff's attorney, at what point do you find an expert? Do you work with experts to put the complaint together? If you do you keep that same crew going into post-filing of the complaint? Do you use the same crew through class certification and summary judgment? Or how do you think about experts once you've got a complaint that you are prepared to work up? Scott, why don't I begin with you?
Sure thing, Ian. And thank you as well. And thanks to your really terrific associate, Patrick Jones, for keeping us all focused on the work product here in pretty unusual circumstances. And thanks to everybody who's listening. Please stick around for the entire program. But afterwards, use your technology, reach out to an old friend and check in. That's at least, one good thing we can do. So Ian, to answer your question, it's, for us, it's like voting in Chicago, do it early and reach out to them often. And there's several reasons for that. One is just prudence, right? In terms of the complaint, since those decisions that I used to embrace many years ago, and now find to be somewhat of an irritant, that Belinda adores, Twombly and Iqbal, and this plausibility standard, the consequences of complaints now tend to be long on detail, create more work for Belinda. We have charts showing, economic effects of the conduct, and the minions on the defense side are going to challenge everything as conclusory. So we want to have the best complaint out there, not only as a matter of pride, but for legal fortification as well. And that, that means involving the experts. We also, in terms of in terms of a little inside baseball, want that especially in the class context, because we may wind up, doing battle amongst ourselves on the plaintiff side under Rule 23G for leadership. And you want to have, the best possible articulation out there. And in fact, you're actually seeing some economic shops that almost have a cottage industry now in these sorts of, quick and dirty analyses of publicly available data to show price effects at the complaint stage. But, there are points beyond that as well. Who wouldn't want to have your expert, contribute to whatever economic theory you're going to put in the complaint, know that he or she is going to be able to live with it. Why on earth wouldn't you want your expert there to help you, articulate what it is that you want in discovery and not be getting, all chaff and no wheat for them? Whether we keep those same experts for certification and trial, that's a different question. And I'll give you the most wholly unsatisfying, ambidextrous, two-handed lawyer on the one hand, on the other hand answer I possibly can. It depends, right? Belinda's going to have her own toolbox of cases there, Dukes and Comcast and Tyson Food and so forth on class certification. And there's going to be this rigorous analysis, even if it's not, strictly speaking, merits issues, except insofar as they bear on class certification. So that's a big investment that you're going to make with the expert. But really, you're looking at several different scenarios, right? Class cert may well be this full-fledged, multi-day, hearing after reports and depositions, but it's essentially a proceeding before the judge. Trial, on the other hand, unless it's, a purely injunctive case or by stipulation, is going to be to a jury. Different audiences, and potentially different experts that you may want to use. Would I like to use the same one? Sure. It's more economical generally, although you can mitigate that somewhat if two experts are associated, with the same shop or can otherwise share support. But, what if he or she, and I know this would never happen with Rob or with Lauren, what if he or she doesn't perform as well as you think in one setting or the other, right? What if there's a good Daubert motion at the class stage? What if there are certain assumptions or positions taken that, I don't much care for purposes of trial? What if there are certain industrial organization issues that are better confronted by one expert, than another? What if class is denied? And as in the rail freight case, which, as you know, we were a co-lead in at the class stage, individual actions actually go forward nevertheless. It used to be on the defense side when I was there, the conventional wisdom was this was the death knell. No one would go forward at that point. But some of these claims can be so substantial and so important to the companies and their responsibilities to their shareholders that they go forward anyway. So in practice, you may well see a different expert or experts at trial for precisely those reasons, and will almost certainly, to wrap up probably a too long answer to your question, will almost certainly have one at least at the ready on the plaintiff's side.
Well, thanks, Scott, for breaking the ice. Belinda, understanding you tend maybe to be more on the defense side, but at times you have been a plaintiff, or even your experience as a defendant receiving a complaint. Does it look like it's been touched by an economist? Do you have some thoughts on Scott's remarks?
I agree with everything Scott has just said. I think it's so important that you start thinking about your experts from day one, especially in multi-party cases, because the good ones, the ones with industry expertise, for example, they go quickly. And so you really need to be in a position where you are out there looking for your expert and putting your stake in the ground as soon as possible. In terms of experts for class certification and then using them again at trial, I agree with Scott again. I think it depends, right? More often than not, from a defense perspective, if I'm preparing for trial, you can probably assume that things did not go well for the defense at class certification. And so you're most likely not going to use the same person at both class and at trial on merits or damages. I don't take it as a hard and fast rule, and you might make an exception. For example, if you had a testifier who you thought did exceptionally well and connected with your judge at the class certification hearing, for example, and there was nothing in the certification opinion that will undermine your ability to use that person again as an effective witness at trial. So that's a circumstance where you might use the same person again because they're already a known quantity and you know that the judge liked them. What I think is a little more common, though, is something that Scott actually referenced, which is to find another expert at the same economics shop that you used previously. So that way you can retain your investment in time and expertise that you made in the consulting staff. But I would caution there, before you do that, you want to make sure that you have the right stipulations about discoverability in place so that you're not getting into any problems in terms of discoverability of communications between non-expert teams.
Very helpful, Belinda. I'd like to stick, for this question, start again with the lawyers, and then I'm going to invite our two economists to kind of weigh in on the receiving end, so to speak. Why don't I start with Belinda on this, but also then go to Scott and then invite Lauren and Rob to weigh in as candidates. Belinda, we're often in joint defense cases. You've got 10 defendants, and Rob, you might be on a panel, or there's 4 plaintiffs, law firms, and so on. We're dealing with constituencies. How do you go about with contending constituencies? We'll start on the defense side. What's your protocol or best practices for interviewing experts? How do you reach the decision, let's go with this expert? How do you go about that? I want to start with Belinda, then we'll go to Scott, and then I'll invite the economists that how when they're pitching, what from their perspective, how should this work? Belinda, why don't we start with you?
I think a step that gets forgotten quite a bit is the important step of looking at the experts' recent cases. I think, we often gravitate to the same experts over and over again without really vetting what happened in their recent cases. So ask your expert for their list of recent cases, check the outcomes, have any of them been deliberated in whole or in part? It's so important that you stay on top of that. And then also look at their other recent engagements. Have they taken any positions that are contrary or maybe just unhelpful to your case? It's important to do that. And as part of that diligence process, also talk to the counsel who retained them in their prior cases and see how they're doing now in terms of how they're testifying substantively, the staff that they're working with. And then, of course, I think the thing that everybody likes to do is hold a bake-off, right? Where you invite all of the experts in to do mini presentations. Personally, I like to try and do them all in 1 or 2 days. That makes for some extremely long days, but I do think it's important to have them, in as close to head-to-head competition as you can have them, so for comparison purposes. And I always want them to bring their consulting staff with them to the bake-off so that you can watch their interactions and you can also talk directly to staff. And then, of course, it's a great way to get new and creative ideas from your economist for free.
Excellent comments, Belinda. Scott, why don't you give us your thoughts on how you've got pluralism on your counsel side and pluralism on candidates. How do you get from one to the other? And then we'll ask their economist to weigh in.
Well, I have to say that I feel as if, Jared Kushner must have mediated between Belinda and I because we are agreeing on everything. Her comments on diligence are absolutely spot on. I don't have anything to add there. I don't know if I would say bake off. That's the old Betty Crocker, but I'd probably say that we can prove Milton Friedman wrong. That you can in fact get a free lunch at the expert audition stage by having them in and listening to what it is that they're going to say. It's tough depending upon the multiplicity of experts that you have. I would hope that you've not narrowed it down to 5 or 6, but you've narrowed it down to 2 or 3, regardless of how big the defense group or the plaintiff's group may be. If you're doing this jointly, the axes, along which they're going to differ. Their paper trail, their presentation skills and general relatability, their pedigree, their availability, their sort of battle-tested readiness. But let me just add a couple things that resonate with me personally. If I can get if I can get the expert that surprises the other side, the one that, where I sit now, they maybe associate with defense work. And at least I know that there's no IED waiting someplace back in their paper trail that's going to explode. I'm intrigued by that. If I can get the one, and this is almost a verbatim quote, if I get the one that says to me, Scott, I really can't say that, I'm intrigued. That's the person who I know is going to stand up to cross. If I can get even better, if I can get the one who says, but what I could say is that's the one I'm really going to work hard to hire. That's the one, who's going to be a good dance partner. And when you're on this selection of the experts, and on this one, I know Belinda and I are going to agree, because we had this discussion probably a year ago over dinner. Someone is going to be the lawyer, or maybe it's two lawyers, right? That's going to raise his or her hand and say, I want to work with the expert. And somebody's going to be the one, or the two that are going to work most closely with the expert and the expert staff. And that better be a relationship that works, or it's going to hurt you, not only in your case, but in your pocketbook. Trust me.
Fantastic comments, Scott and Belinda. Lauren and Robert, why don't we go to you? So these are lawyers looking to shop, and how do you sell? What's the best credibly and with thoughtfulness? Can you give us insights from your perspective?
From my perspective, working in this group setting, I can't emphasize enough that the work between the expert and the team is an important aspect of the whole thing. So I think, I always encourage lawyers to let me bring my team to the meetings, because it turns out in a lot of cases, the team or the leader of the team is the one they're working with more on a day-to-day basis with me. But it's also going to be clear that while I have a team that's working with them on the day-to-day basis, it's got to be the expert, the guy who's going to get on the stand and have to defend that stuff, who has to drive the ship. So I'm very much a believer in presenting this environment where there's a driver and there's a team working behind the driver, working together for the same goal. So that's an important aspect of it. I get how the team is important, and I agree with Belinda and Scott, especially in the class cert setting, where having a team and maybe having multiple experts in case something happens, you don't want to use the same expert in the second phase. That's important, and certainly preserving the efficiency of the team is relevant to that. But at the end of the day, one person is going to be up there in the stand telling the story, and that one person has to be comfortable with work that's been done by the team, with the interaction between the teams and the lawyers. So I think getting everybody in that first meeting on the same page, and I agree with Scott, and I'm glad to hear him say that, because I've taken Scott's approach a lot to say, obviously it's a repeat play game for experts, and experts have to be consistent across cases. You have to follow the economic theory and the evidence wherever it leads. And there are times when I've had to say to clients, I can't say that, but let's find something I can say that I'm comfortable with as an economist and with what I know about the facts that actually advances your case, or let me help you find somebody who can advance your case. I think it's important, that honesty in the relationship is important, because you're under oath, you're on the stand, you've got to put up a consistent, you've got to believe the storytelling, or else they're going to see through it. So I think it's important to kind of probe, for the lawyer probe, how strong does this guy believe? Obviously, facts aren't completely developed at that stage, but how strong is this guy's economic beliefs consistent with what we're going to need to say in the case? I think that's an important thing for lawyers to probe at and in that early stage. So I'll stop there.
I just wanted to pick up on something that Rob said in terms of the supporting team, because if there's nothing else that I would hope people take away from our discussion today, that's one of the most critical things, is meeting the team and having confidence in those people who are supporting the expert because if they're vested in the expert in the case, they're the folks that really ensure that mistakes don't get made. And I've been really fortunate to have worked with a number of those people in supporting roles along the way. And the other thing I would say, for those of us who have gotten a little longer in the tooth, is those are the people that you meet during your career as you're working with consulting shops, not so much with academic experts, but certainly with consulting shops. Some of those supporting people are experts future testifying experts that you will be able, to cultivate and that you will find to be extraordinary dance partners in the future. And there's it has the same sort of satisfaction, as working alongside one of your lawyer colleagues for years, is seeing one of these testifying experts, develop.
Excellent points, Rob, or Scott, I should say. Pardon me. I wanted to start with just amplify something Rob said. It's Ian. Before we slightly develop something that's been mentioned, I think Rob's point about on the pitch, the testifying, the nominal testifier, he or she, that they need to convey to the group that they're not an empty suit. They've got to evince ownership. It's something I tell young lawyers. I'm working for a client. I've been practicing 29 years. That third-year associate, that client is as much that third-year associate's client as it is my client. We've all had experiences where the top person, they're skating, and that will not work long-term. Let me develop something. Maybe we could start here with Belinda, and then go to Scott, and then get Rob's thoughts and Lauren, if we've got Lauren back on. But let me start with Belinda on this. And some of you, Scott and Belinda, have already alluded to this, and Rob. Let's posit a situation where you've got two of these star economists, but you think their consulting team, the back office is, the back office makes you a little hesitant. On the other hand, as shop A, and you got shop B, where you've got this, maybe they're not as household brand names at the top, but you really like the back office. They have smart, young PhD heart. They got a lot of hunger, and they give you a lot of confidence. So let's presume you've got this dichotomy of strong front office, so back office, maybe a little unproven on firm A. Firm B is a little bit unproven front office, really great back office. Belinda, how do you think through those issues?
Yeah, that happens more often than not, unfortunately. I think at the end of the day, I am going to choose my testifier based on the testifier and the testifier's experience and how they're going to do at trial. But you absolutely do need to look at staff and have a frank discussion with your testifier about, any perceived weaknesses that you see in their staff. That's the only way they'll ever be able to address it and work with you on it. You might also, if you have the luxury of an endless budget, then you might also retain the other person who you thought was a fantastic number two to be a side consulting expert. I know, you oftentimes as the lawyer try to force testifiers to work with consulting teams from other shops, and they hate it, and they often won't do it. But so in the end, you might be able to kind of finesse that and make that happen in the background by retaining your testifier who you love and then a consultant on another shop, and then you be the one who's the conduit putting all of it together.
Thanks, Belinda, for those excellent insights. So Scott, let's go to you now. So recall the dichotomy is as follows. You're looking at two economic shops. The front office in shop A has really brand name academic testifiers with great experience in the front office. Their back office, though, gives you pause or you're circumspect about. Firm B has perhaps more untested front office, but their back office you've worked with and you think are really superb and hardworking and bright and creative. How do you work through this dichotomy, Scott?
Okay. Belinda has this unlimited budget, so she's hiring a shadow expert, I guess, which I've done in the past too, and frankly, sometimes it's very useful. But on the plaintiff side, we tend to be a reasonably rapacious and greedy bunch. So if you give us a dichotomy, whether it's honest broker or advocate, or whether it's testifying expert and back office, our response tends to be, why can't I have both? And in some instances, I hate to share this little secret. I'm sure Lauren and Rob will lash out at me for this, but in some instances you can mix and match, and let's face it, we as counsel for our clients are our ARE clients of the experts and of the supporting personnel. So just in the same way that there are virtual law firms being put together across different firms, and they manage to peaceably coexist and even achieve some terrific results. I've done it at trial with the competitor firm. The same thing actually can happen in certain circumstances, and you need to be cognizant of what the rules and roles of the particular expert in a particular shop are, and whether interpersonally the relationship is going to work. But in many instances, approach the expert first, or approach the shop with which they're affiliated second, and try and figure out whether you can do that.
Thanks, Scott. Lauren, how do you go about persuading the lawyers that you have both a great front office and a great back office, and they should go with you and your team?
Well, I always like to think that is certainly true, that we do have both a good front office and a good back office. I think it is really important that the testifying economist have a good relationship with the people, with the staff team. And so, while Scott may have good experiences working with a testifier from one shop and a support team from somewhere else, I'd be more inclined to think you can teach an old dog new tricks, and you can teach the new dogs better tricks. And maybe whatever the piece is that you think that you are missing, let's be upfront about that. Let's talk about it early on, figure out what the issues are. But there could be some reasons why is it that you feel that you had such a good, strong working relationship with the consulting team at one shop, but you were hesitant to use their testifying expert? As somebody that is part of my role, I am always looking for opportunities for some of our up-and-comers to testify. Why not give an opportunity to somebody that's inside the consulting shop, even if they haven't yet testified before, so they don't have as long a CV, but if there's something there that you've got a good working relationship with them, and the legal team and the economist team are working really well together, maybe there's an opportunity to develop the lead consultant into the testifier and see whether that can work out. And perhaps alternatively, if there are reasons why you've got a testifier that you really want, but you're not too comfortable working with their team, what are those reasons? What are the sticking points? Let's have a conversation about those so that we can see, on the one hand, maybe we assemble a different team as the back office, but ideally, maybe we can address whatever those shortcomings are and figure them out. And if it's, something technical on the issue of just not being able to go deep enough or not being available, then it would be great to think that we can solve those issues and find, find a good working relationship so that you've got the testifying expert and their team together, because I think that is a pretty important relationship to be able to fall back on, especially as you get into the deposition prep and then ultimately trial.
Excellent comments, Lauren, about the young or the emerging consultant flowering into a testifier, and also about the point people dealing with the lawyers. I want to come back to both of those in just a minute. Rob, what are your thoughts on how people should think through this dichotomy?
Well, I've been around a long time, so I've done a little of both, right? I've worked a lot, obviously, with my team that I'm comfortable with and have a good working relationship. And over the years, I've worked a lot with both when I was younger, being the consulting person supporting another expert, and later in my career, being the expert supported by teams from other shops. So I'm a little circumspect about it in the following sense, right? Because as I said in my earlier question, right, the expert is the one that's got to get up there in the stand, and in some of these complex antitrust cases, there's a lot of work that's done, and obviously they're too complex and too large for the expert to have really been down the weeds in how this work was done in a lot of cases, especially when it comes to the early stages of just getting data ready, et cetera. But the expert up on the stand has to have 100% faith in the team that did that work, or else it's easier in a cross-examination if you see the expert starting to question how the analysis was done. That can be a very bad thing for you and your client. So knowing that as the expert that you have 100% faith in the team that's supporting you is really, really important. That doesn't necessarily mean I'm completely against working with teams from other shops. As I said, I've done it, but understanding that relationship, that it's more than just I as a lawyer am used to working with this back office team, but they don't have the right expert in terms of background maybe, or industry expertise or something like that, and I really want the industry expertise along with the team I'm familiar with. That I get that, but it really has to be thought through that at the end of the day, as I said earlier, one person's going to be up there on the stand, and that one person has to have 100% confidence in the work that was done. And so that's important. But thinking through now, still, as I said, I've done this with other teams. It a little bit depends on what's driving the decision to do that from the legal team standpoint. Is it I'm bringing an expert in late in the case or later in the case, and the back office really, the other firm's back office has really invested a lot of this case, and they've got a lot of institutional knowledge or background with data or things like that, such that there's an efficiency to having those guys do it? Or is it I've got the expert I want, but I don't trust the back office from that expert's firm? That a little bit drives the call. I'm more comfortable, obviously, if it's the former, right? If there's a back office team that's already got deep expertise in the data or in the facts of the case, and I can work with them. I also, as I said, have had the experience of having been around a long time, and so I know lots of people. So even when I've worked with other firms' staff, a lot of times it's staff that I'm familiar with over the years and have some comfort with. And so I think it's just important to understand how this all plays out, and how important it is for the expert to really have confidence in the staff that's done the work. I just want to make sure that emphasis gets across.
Very vital point, Rob, and important insight that connection between the front and the back office has to be strong, resilient, and steadfast. Excellent. I want to briefly touch on 2 points, or ask each panelist briefly to touch on 2 points that Lauren mentioned before we move on, because I want to get to take the expert discussion to later on in the proceedings, later on in the lifespan of the case. But before I do that, Lauren had mentioned 2 points that I'm going to ask each person briefly to comment on. First, how do we think about, the up and coming generation? There has been a tradition. There's been the defense side, I think, has arguably fallen prey to, the same old names, and we need to cultivate and groom young talent just as we do on the law firm side. So how do we think about the young emerging consulting economist who may flower into a testifier? That's on the economic side. And then how do you think about who's the right lawyer point person to be dealing with the economist? Belinda, why don't I start with you, if we could just quickly run through these two issues, well, starting with you.
Sure. I think you are exactly right, Ian, that lawyers tend to default to the same small group of testifying experts, and we are often not doing ourselves a service by doing that, and we need to do more to cultivate the next generation of testifiers. And so something that Lauren mentioned earlier, I completely agree with. You and Scott also, is just you want to be making and developing relationships with the number twos on all of your teams, because they will be the ones who are growing up with you as you were growing up as a lawyer too, and eventually taking the role of a testifier. And I think it's important as a lawyer to help guide those number twos and help advise them on what they could do to make themselves into a more appealable candidate as a testifier. Often I've talked with consulting staff who I really like and have encouraged them to look for testifying opportunities outside of antitrust cases. Given the size and magnitude of antitrust cases, you are really it's not likely that you're going to go to someone who has absolutely zero testimonial experience. But help the folks who you like find other opportunities, whether it's a case outside of the antitrust world, a smaller breach of contract, commercial dispute, or even a pro bono case where they can be a damages witness in some kind of pro bono case. Help them find opportunities to testify, and then you can use those opportunities and go to your client and say, look, here are all the substantive reasons why I think this person is fantastic. They know the case, they know the industry in and out, and here are the couple of times when they've testified and they've done well, and that just gives me some kind of a hook that I can use to explain to the client why we should take a risk on this person.
Fantastic
and then
insight.
You're just quickly on your second question, Ian, in terms of what lawyer to pick on the team. I think you often, at big firms, you often get associates who have economics degrees from undergrad who gravitate towards working with economists, and I think that's fantastic, and I always encourage that. But I always encourage other associates who don't necessarily have that experience to do it too, because obviously your role as a lawyer is kind of translating what the economist says and does to the judge or the jury. And so more than anything, I think it's just finding someone who is willing to really dig in, work closely with the economist team and with the consulting staff, and then really get to know all of these issues and understand them.
Thanks, Belinda. Excellent insights. Scott, if we could just be brief, because I'd like to move to a broader issue.
Sure. No, I'll be very brief because I agree with Belinda on both points. I think everybody, any expert has been in the situation at some point of being a first-time testifier. I think clients understand that. The client needs to meet the expert. The client needs to know, the expert is really vested in the case if it's a full-time testifier, and a first-time testifier. And I think the client needs to know that you've seen the person, working behind the scenes or working on smaller matters for a long time and having done the work well. And I think you need to get across the point that it's incredibly important to that first-time testifier to make a real mark in the first opportunity. Whether it's Belinda or me or many of our colleagues, he or she knows that we know a lot of people out there who are going to ask how the person was to work with and how he or she performed, and it better turn out right. On the second point, I agree wholeheartedly with Belinda. The one thing that I would probably put a very fine point on is the right lawyer is the one who can assist the expert and the expert's testifying staff in focusing on whatever the 3, 4, or 5 key points of that testimony need to be, and not allow them to go down a rabbit hole if it's avoidable.
Thank you, Scott. Great insights. Lauren or Rob, anything you'd like to add before we move on?
This is Rob. I'll just add real quickly. Obviously, professional development is important for me and my staff, and so I agree with Scott and Belinda's point. I think, especially in the way our teams work, there's kind of a point person on the consulting staff, and those guys spend a lot of time and effort kind of really delving into the facts and really thinking about data issues and really interacting with lawyers about issues in the case. So I think there is a real opportunity. One of the benefits you get with those guys is oftentimes they've spent a lot more time with the grappling with the issues of the case than the expert who tries to sweep in at the end. So obviously, in a situation where deep knowledge about facts or documents or issues with data is important, in my experience, the time the staff person spends thinking about those issues can pay off when it comes time to have to explain them to somebody else.
Good points, Rob. Lauren, anything you'd like to weigh in on in these two issues?
Sure. I think, one thing that I would add, echoing what Scott said, everybody has to have their first time up there. My experience from having been in a number of different jury trials, I've seen, experts being given their first shot, but also a lot of lawyers getting their first chance to cross-examine someone or put on some testimony. And what I feel that I see time and again is the courtroom gets behind that person. If somebody is up there trying to do something for the first time, and even if they sounded a little bit nervous and they're not polished, and I've seen a lawyer trying to struggle with what sort of an objection to raise, and the judge helps them out. There's this feeling that the jury then is also very much on their side. Everybody wants them to succeed, and so it's something that I would recommend for the lawyers on the phone to take to their clients, where you may want to see somebody very polished and experienced right from the beginning. You're also then going to spend some time vetting all of their prior testimony for the last 20 years versus, bring someone along that doesn't have that big, long track record that you have to go through, and have some confidence that if they've got, if they've got something that is resonating with you, that maybe that will resonate with the jury as well. And so to have some confidence that you'll be able to bring that out at the time of trial.
Thank you, Lauren. Excellent point about giving younger lawyers their opportunity. Something we need to keep at the front of our minds. Let me step back now and talk about, I want to inject kind of more of an architectural question on this. If we can just start with the lawyers, Scott, maybe with you, and then Belinda, and then I'd ask Lauren and Rob to weigh in. How do you think about experts in the overall architecture of your case? I mean, going a little bit to the title of this program, our experts, there's one school of thought which says, look, experts just cancel each other out. It's a little bit like mutually assured destruction in the height of the Cold War. Or, can experts really carry the water and win your case for you? Where do they fit in the overall architecture of a case? A case with great facts for you is what's going to do it, and the expert is, icing on the cake? Or can experts really get you over that finish line? How do you think about experts in the overall architecture of your prosecution and your narrative?
Belinda, you want to start? Or do you want me to?
Go ahead, Scott.
Okay. Well, you might have been better off with Belinda starting, Ian, because I'm going to give you an answer you're going to hate again, and that's it depends, right? And it's going to depend on the nature of the case, and it's probably going to depend on, to some extent, but not with 100% or even 95% confidence on which side of the V. Is it a competitor case or is it a class case, right? Is it a cartel or is it some sort of unilateral conduct? And are there cooperating witnesses? Or if you're on the defense side, do you have, a real advocate, face of the defendant company? What does the supply or distribution chain look like? And, and where do the witnesses fit in for the plaintiff or the plaintiffs? And from that perspective, you can kind of start to create the exoskeleton, if you will, as to where the expert is going to fit in at the start, of the case, or close to the start of the case, to give an overview of the industry, or later in the case, to wrap things up and tie together prior evidence. Is it largely a document-driven case? Assuming that you don't want to call an adverse witness in your case if you're the plaintiff, which I've personally seen blow up. Thankfully, not on me. But certainly one too many times to do it without having some other option. So it's just not a one-size-fits-all answer. But if the expert is going to be useful, he or she is going to have to, tell a story and bring certainly, many of the documents and data to life, so that they're not just exhibits introduced on a screen at the end of the case. So it's the expert is maybe not the sole driver of the case, but a critical part of theoretically where you're going to go, and probably conveying at least one or two of your principal trial themes.
So, in other words, Scott, the expert may not be the holy grail. It depends on the circumstances, but they can certainly help drive through a few themes. Is that a fair assessment? And it depends.
I think it's a very fair summary. Yes.
All right, Belinda, how do you think of, you've been sued, a huge class action involving 9 years, very important electronic product. How do you think of experts in the overall scheme of things? Is it just neutralize the other person, or is it to make some cover some affirmative ground for you?
Yeah, so I'm going to be far less wishy-washy than Scott on this one. And I'm going to say that I think you absolutely want to build your case around your fact witnesses and the contemporaneous documents. That's how you're going to be credible with a judge and a jury. And then you use your experts to validate anything that may not be immediately intuitive about your defense. But I think it hurts you credibility-wise if you try and have your expert do too much. And if you build your case around the expert, because it can be obvious sometimes when you do that. And of course, that's the ideal world, and there are many instances when you don't have access to the witnesses that you want at trial, and so then you do have to use your experts to fill in holes and tell the story that you would rather tell through fact witnesses. But even then, you need to be really careful when you are putting a heavier lift on your experts, that you're not, sending them out there on a bridge too far and having them do too much that they reasonably can't, within their expertise, opine on.
Wonderful metaphor, Belinda, the Arnhem Bridge in World War II. Lauren and Rob, so the lawyers are interviewing you, and the lawyers kind of, I want you to carry all the water, how are you pitching your role in this architectural point? How you should be thinking about me as an economist in your overall architecture, lawyer. Could you address that for us? Lauren, why don't we start with you?
Sure. So I think a little bit, just to echo what Scott said, what it depends on for me is what the scope of the testimony is that I'm giving. So, there could be some aspects, if it's something related to relevant market or market power, that could be a little bit dry, and, that would not necessarily depend on all of the ins and outs, the emails back and forth, and the juicier bits of the underlying documents. But something like damages, then I think then you absolutely need to make sure whatever the ultimate model is very much tied to the facts of the case. And so there's a lot of scope there for making sure that you've considered all of the information in underlying documents, and also in the, on the defense side with damages, because that typically comes in at the end of the case. If you're in a trial setting, what has already gone in beforehand, whether there have been some things that you think the jury didn't quite get, or points that you'd want to emphasize. If you've built that into your experts' work as well and make sure that they have considered all of those same documents, I think it gives another opportunity to be able to tell the story in a different way or tell the story in a different voice, wake the jury up a little bit more. And you can only do that if that is built into the analysis. So I think the thing that I would emphasize is, again, as it's something I said earlier, be upfront right at the hiring stage of what it is that you're going to want your expert to take on. And if you envision that there is going to be some of this storytelling aspect, to make sure that they do consider all of the documents, see what you would say are the bad documents, see the good documents as well, make sure that every single thing that is ultimately going to be put in front of them, they've had a chance to consider and weave it into their analysis. And if their analysis at the beginning is, really, for maybe budget reasons, it's trying to keep it really tied to a very specific point of economic testimony, then there isn't as much scope to have thought about what all of the underlying story is of the interactions between the market participants.
Great points, Lauren. We'll come back in a few moments to the importance of the expert understanding the actual record. Rob, would you like to weigh in on this issue,
Sure.
the architectural issue?
Yeah, real quickly, I think where the economist plays a good role is as the teacher, giving an economic theory a context within which to evaluate evidence. To me, that's the storyteller role that I think economists and experts in general should play. There are fact witnesses, there are documents, there are complicated data analyses done by economists on both sides, all of which is to build a context within which the fact finder can evaluate the facts of the case. So I think the role of the economist as providing that context, not laying out the facts, but providing the context within which to evaluate facts, is the best role for the expert to play. I think oftentimes you run into, especially when there are complex data analyses done on both sides, the economists like to, dwell on the disputes about econometric methodology, which I think is the worst thing an expert can do in the context, especially of a jury trial, as opposed to let's give you a framework within which to evaluate the facts of the case. I think that's really the role that the courts envision experts should play, is give them a framework within the science of economics to evaluate the facts of the case. I think that's the role experts should play.
Thanks, Rob. We're approaching at the end of our time, but there's two more topics I'd just like to go into. But if we can just be economical in our expressions here, we do have the time to cover them, and I think we should. I first want to go to expert reports. It has been said that the drafting of an expert report is akin to watching the proverbial sausage be made. In an ideal world, what is the proper role and balance between the testifier's input into the report, the consulting team's input, counsel's input, and feedback? Those are four constituencies. If I could start with Rob and Belinda on this and then get the economist's view, how do you manage the process of writing the report, making sure your economist is in the saddle and you're managing these constituencies?
Well, let me be very brief then and focus on the testifying expert, because I think whatever happens, to use your metaphor in terms of the sausage making, the most important thing is that the expert embraces every ounce. The testifier embraces every ounce of that sausage in terms of that report. Has to be the final pen and has to own every word and every fact that's in it.
Well said. Belinda?
I agree with that. And I think part of that process means that we as lawyers need to show some restraint. I know we like line editing briefs and things like that, but you just can't do that with an expert report. You have to use comment bubbles, kind of convey concepts and theories to the testifier and their team. and then really only very, very few line edits when necessary to correct factual statements or things like that. It's got to be a report that comes from the testifier.
Great points, Belinda. Back to ownership. Lauren and Rob, how do you think about ownership when you're sitting as a testifier?
So I, certainly would love hearing what Belinda just said, that, I pay a lot of attention to all of the words in a report that I'm given, and then they are in my words. And when it does look like sausage, when you get a red line back and you can see that there have been many different people putting in their thoughts, and sometimes somebody has suggested something and then somebody else from another law firm has crossed it out and put something else, that's going to show up. It's not going to be in a consistent voice. So I think, just echoing what Belinda just said, that to have it in a consistent voice, but where the lawyers have tremendous input is they've got people in the shop that have seen the entire record. And so to be able to point out where there could be areas where, there's additional facts that maybe haven't been considered yet, that's very key input. But the wordsmithing is maybe less important in my view, and I think would detract from then when you're trying to testify and actually say it, you want to make sure that it's all words that you would typically use.
Thanks, Lauren. Rob, do you want to briefly weigh in before we go to our final issue?
Sure. I fundamentally agree with what everyone said. The expert does need to own the report. I agree with Lauren's point that oftentimes it's useful for the lawyers who often have a deeper knowledge of the record to say, hey, there's other documents on this point you should take a look at, review them. I leave it up to you whether to include them or not. That's usually, in my experience, the way they work. Sometimes they're more adamant about what documents they want highlighted than others. But at the end of the day, once again, the expert's got to defend the work. So the expert has to be comfortable with every word and every analysis done.
Well said. Let me go to the final scenario. And I want to, before I do that, thank Belinda, Scott, Lauren, and Rob for a superb job. Let me go to the final issue. You're 30 days out from an expert deposition in a significant monopolization case. And with this, I'd like to start with Belinda, by the way. So Belinda is 30 days out from an expert deposition in a significant monopolization case that she's defending. She has a voluminous fact record involving documents and testimony, voluminous econometric record on both sides, but her testifier has been gliding on the case. Belinda, you're 30 days out from the deposition. How do you get Professor Smith ready for that deposition?
Right. So let me, before we finish, also just say thank you, Ian, to you and to Patrick Jones and to John Roberti and the ABA for hosting this panel. But to answer your question on this hypothetical, and hopefully this really is a hypothetical because 30 days out is really, really late to be getting your testifier engaged. But I think what you need to do at that point then is have a serious sit down with your expert and their staff to understand what your testifier knows about the case, what they need help on, and what's going to be the most effective way for your testifier to ingest and digest all of that in the next 30 days. I think it will depend on who your testifier is. If it's someone with very little testimonial experience, you're going to want to moot them and moot them again and moot them again, and really just kind of practice with them sitting in the hot seat. If it's someone who's been around the block many times, then I think you as the lawyer need to cede some control over the prep to that expert and really mold your prep to what will work for that expert in terms of getting him or her up to speed on the facts and ready to testify. I mean, some of them, some testifiers, we've all worked with many of them who just like to sit with the report, read all the footnotes, all the material cited in there, and just, work internally by themselves. And I think if that's an expert who has done that many times and knows that works for them, then as a lawyer, you need to resist the urge to interrupt that process.
Superb points. Scott, would you like to weigh in on this exigent circumstance?
Yes, and look, it never happens for us, who work in the law that the vagaries of work causes to glide on a brief at the last moment. So it's peculiar to economists.
It's purely hypothetical.
Purely hypothetical. As in most instances, I think Belinda and I only had one serious disagreement, and that's because she has, the luxury of being, having experts who are 100% validators, which we don't always have on our side of the V. But I agree wholeheartedly with her comments here. I think, by the way, Ian, it's an excellent wrap-up question on your part, because it really does underscore many of the things that we've been talking about, through the selection process and through the preparation process. If you pick an expert, who's a Nobel laureate, guess what? You're probably going to be more stressed on time commitments than you are with somebody who's not. If you pick somebody who's a first-time testifier, they're probably not going to have the same focus in terms of their testimony at the time that they're doing the deposition that an experienced testifier would have. They're probably going to require more preparation. You need to think about that in advance in terms of their time commitments. And again, most importantly, and Belinda mentioned this, I would just underscore it. One of your most significant allies, the most important person or people to have in the foxhole with you. I know you love the Army analogies here, Ian. To have in the foxhole with you for that that circumstance where the expert is not ready is the support staff, and there have been many occasions on which the critical person in getting the expert focused, up to speed, and knowing what's likely to be significant cross in the deposition, and following up if it needs to be a 2-day or 3-day session broken up to do that, is the support staff.
Excellent comment, Scott. Lauren and Rob, would you like to just weigh in to close us out? And I'll just thank everybody at the end.
Sure, I'll weigh in. And first, I'd like to thank you as well, and thank you especially for persevering with the various technical challenges that we faced trying to put this panel together. It would have been nice to have all been in person to do it, but that, of course, wasn't possible. I agree with what Belinda and Scott have said. Hopefully this would never happen, that you've been upfront right from the beginning of what you expect from your expert and their team. You've been checking in with them. They have written their own report because we've just said that that's the best thing to do. They are then ready to testify. They've got to, maybe get up to speed on some of the behind-the-scenes things, but if we've done all of the other steps right, then we are not 30 days out from the deposition with the expert not really knowing what the facts are. But I think, if something happens and this is the situation that you're in, then I think the remedy is not to do the prep right the day before or 2 days before the actual deposition, and do prep number 1 on 30 days out as soon as you realize that you're in this position. Because if you do a really good strong prep where you are cross-examining, doing some mock cross with the witness, that will certainly put sufficient fear in them that they will want to make sure that they are well up to speed on all of the documents and all of the information before having to face that in the real world rather than just in a mock situation.
Thank you, Lauren. Rob, would you like to weigh in?
Sure, and I too thank Ian and everybody else. It's been a pleasure working with you. I have nothing new to add. Obviously, I having been around a lot, I have seen experts who like to put things off to the last minute. I agree with Scott's point about keeping the staff involved, because I often think that the experts are more beholden to the staff and more willing to, if the staff cracks down on them, to toe the line than sometimes if the lawyer cracks down on them. And it's a lot easier for the staff to talk economics with them, to understand what the economic issues are that are in the case. And so, having staff involved, and I agree with Lauren's point about if you're in this situation where you have an expert who's not going to put the time into prep, forcing him to put the time into prep earlier rather than later gives everybody less heartburn. So I think the sooner you can figure out how focused is this expert on the case and how much time is it going to take to prep him or her to be ready for the deposition, the easier everyone's life's going to be.
Well said, Rob. Words of wisdom, keeping your finger on that pulse and doing so real time. That's a matter for all constituencies. Very well said. I'd like to thank our distinguished panelists. Be safe and well, everybody, and thank you for your participation. John, back to you.
Ian, thanks. Very, very interesting presentation. Jim, let's take it back to you. What do you see as the major takeaways from today's session?
Well, there are many important takeaways, but just to focus on a couple that these attorneys and economists have made. First is you should start a careful and detailed search for experts and non-testifying support staff as early as possible in a case. As Scott Martin indicated, for plaintiffs, it's important to get the input from economists during the drafting of a complaint to be sure it's fact-based and constructed with economically consistent, supportable logic. Similarly, defendants need to know the degree to which the facts and economic analysis in the complaint are supportable, where flaws or weaknesses exist, and how to challenge any weak points. It's really very important to evaluate the ability of the testifying expert and the non-testifying staff both. So
Jim, what's your second one? That's an important one. What's your second takeaway?
Our second takeaway is that it's critical to clearly define the role of the expert in the overall structure of the case. For example, Scott believes that it depends on the nature of the case, the fact situation, and the strengths of the expert. Belinda Lee sees the expert as validating the documents and fact testimony and filling in where there are gaps in other evidence. Lauren STIROH indicates the role depends on what the expert is being asked to testify on. Maybe it's opinions on market power or antitrust damages. And Rob MANESS, the other economist, believes that the role of economists should be a teacher of the relevant theory and how the facts and the data relate to that theory.
Interesting that all distinguished people sort of all with different views about the way to approach it. Number 3, Jim, what's your third big takeaway?
Well, when preparing to testify or to prepare testimony by an expert for a deposition or for a trial, one size simply does not fit all. Some experts, such as ones with limited testifying experience, some academics, and experts who frankly tend to procrastinate, need attorneys or non-testifying economic support staff to organize meetings with the testifiers early in the process. By putting these experts under some testifying conditions, it'll ensure that they will have crisp answers and know the factual record as they need. Other experts, however, are well organized. They have done this a lot. They have a reliable approach that works for them, and the attorney should accommodate that approach. So, in short, you need to know who your expert is and what the best way to prepare them would be.
Jim, is the Economics Committee sponsored this panel? It's really a really great one. Can you tell me a little more about what the committee does and why younger attorneys and economists should get involved?
Well, as the program illustrates, the committee sponsors and organizes seminars and produces a newsletter, organizes and produces handbooks that provide useful information on important topics on legal, economic, and frankly, the practical aspects, as this one does, of antitrust and consumer protection law. For example, we are currently editing 2 economics handbooks, one on market power and one on Daubert challenges to exclude economic experts. Another thing that we do is these projects provide opportunities for economists and attorneys to research, write, and speak on important antitrust and consumer protection topics, and also so to gain the recognition for their work. The committee also gives its members the opportunity to affect public policy. For example, the committee is very active in drafting section comments on key policy and legal issues in the U.S. and frankly elsewhere. We've been major contributors to the section's comments on the FTC and DOJ draft vertical merger guidelines recently, and on the FTC's hearings on antitrust and consumer protection in the 21st century. In addition, we've drafted comments on proposed digital platform regulations in Australia and Italy, and the EC's white paper on calculating damages in private cartel cases. Finally, it gives the committee members an opportunity to meet and work with the experienced attorneys and economists, such as the ones in this session, who are thought leaders in the area.
Jim, thank you. Pleasure as always, and really great insights. And I also want to thank the panelists for all their time and preparation. And most importantly, I want to thank you who are listening. Please be safe, be well, and we will look for you next time.
Thank you for listening to this 2020 Virtual Spring Meeting edition of Our Curious Amalgam. It is produced and shared around the globe by the American Bar Association Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard and would like to become a member of the ABA Antitrust Law Section, visit us at ambar.org/antitrust to learn more. If you have feedback for the podcast or are interested in participating in a future episode, please reach out at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.